Mr. Britt, my name is Rick Gammon, and I represent along with Joseph Attorney College and Richardson in this case. Have we ever met?
No, sir.
Okay, and you have been interviewed by the state of North Carolina, either someone with the DA's office or by law enforcement officers, at least 4 times. Is that correct?
Yes, sir.
And one of those interviews on 3/27 of 2015, that one lasted for just over 3 hours, did it not?
Yes, sir.
Okay. And you're represented by an attorney, are you not?
Yes, sir.
You're represented by George Kelly, is that correct?
Yes, sir.
And George Kelly's sitting right here.
Yes, sir.
Did Mr. Kelly tell you that I requested to have an opportunity to talk to you before this hearing, before your testimony?
Yes, sir.
And that he refused to allow me to talk to you before this hearing and this testimony?
Yes, sir.
Now, originally in this case, you were charged with an indictment with 2 counts of first-degree murder and conspiracy to commit robbery and conspiracy to commit burglary and robbery and burglary. Is that correct?
Yes, sir.
Well, let's take them one at a time. You were charged with the first-degree murder of Mr. A.L. Brown, were you not?
Yes, sir.
And you're guilty of the crime of first-degree murder with regard to
Objection.
Mr.
Reflect jury's left the courtroom. I hear from you, Mr. Lively.
Your Honor, I think that the defense is limited in what they can ask to what he pled guilty to, what sentence he received, and I think it's improper for him to ask if he's in fact, or tell him that he's guilty of first-degree murder. I don't see that should be admissible or what its relevance is. So I just ask that you not ask him to answer that question.
I hear from you, Mr. Gammon.
Well, the relevance is this, Judge. He's guilty of first-degree murder, and they dismissed that charge. He's no longer facing at least life imprisonment without parole, as opposed to the 50 to 72 months that Mr. Lively talked about. And secondly, the state dismissed the first-degree murder, so it's a concession that's made to him. And if, in fact, he's guilty of first-degree murder, it's a significant concession.
Well, can't you accomplish that without asking him whether he's in fact guilty of first-degree murder?
I guess we could argue to the jury that based upon his testimony that he's guilty of at least felony murder or first-degree murder, but I think it's only fair to allow me to ask him what he thinks with regard to whether or not he's guilty. If he says yes, then fine. If he says no, then I want to cross-examine him as to that, as the basis of why he thinks he's not guilty of first-degree murder. I mean, to say that Mr. Lively, I'm sorry, you're thinking so.
No, go ahead.
Well, Mr. Lively indicates that it's not relevant. How could it not be relevant? And one last thing, they're the ones who have now introduced evidence that this man, Mr. Britt, based upon his testimony, is guilty of at least felony murder, which is first-degree murder in the state, and would subject him to life in prison, at least life in prison.
Go ahead.
Now, it's not a question whether the jury decides guilt. He doesn't decide guilt. Guilt is a legal term. He can be asked, didn't you say that you had a plan, that you went over there, that you knew somebody had a gun, and that you acted with these people, and that during the course of that robbery, you now understand, based on your conversation with the defendant, that somebody died? He can ask him those questions if he wants him to reiterate all that again. But this defendant, nor anyone else in this room, other than these 12 people over here, decide what guilt is.
Let me see the plea transcript that he signed. I mean, didn't he admit that he was guilty in his plea transcript of certain crimes?
Said he was guilty of accessory after the fact of conspiracy to the plea and to the robbery.
I will let you ask, do you understand that if someone died during the commission of a felony that you are involved in, that you would be guilty of first-degree murder and subject to life imprisonment at a minimum?
But, Your Honor, the only reason I ask you with all due respect, to think that is that if this man doesn't think that he's guilty of first-degree murder, then that means he receives nothing from that plea agreement in his mind, and as a concession for him testifying. I would submit I should be able to ask him, you're guilty, aren't you? I mean, if he's not, I apologize, I know you're thinking that.
Well, he could also believe, it's also possible that he could believe that he may not be guilty, but there was sufficient evidence to convict him, and so he hedges his bet and takes a plea.
If they want to cross-examine him on that, that's fine. But the motivation that he has for testifying in this case, I submit I should be able to ask him that part of that motivation is the fact that he is guilty of first-degree murder, and the state has taken life imprisonment and the death penalty off the table. Because you have to believe his testimony to believe he's only guilty of felony murder, first-degree murder under the felony murder rule. If he went in the house and shot somebody, then he's subject to the death penalty.
Anything further from the state?
I think that he can be asked, did you plead guilty to these crimes? Why did you do that? Or did you talk with your lawyer, you talked with him about the state's evidence, and your lawyer advised you to do this because you were likely going to be found guilty of first-degree murder? But to ask him whether he's guilty of first-degree murder, he's not guilty until he pleads guilty or he's been found guilty.
We're not trying him. This jury's got nothing to do with him as far as trying him is concerned. So when Mr. Cummins says, that's up for the jury to decide, it's not for the jury to decide whether he's guilty. I want to know what he thinks. And if they want to cross-examine him, redirect him on all those issues, that's fine. That's up to them. But, by the time I start talking about what Mr. Kelly told him or Mr. Brandon told him about this or that, I'm going to give objection because he's his attorney-client privilege. So the concessions that he believes were made and the motives that he, for testifying, I submit a fair game.
Objections overruled. Bring the jury back in.
Mr. Britt, I believe I asked you if, in fact, you were indicted for the first-degree murder of Mr. A.L. Brown. Is that correct? You remember that?
Yes, sir.
And it is true that you were so indicted. Is that correct?
Yes, sir.
And it is true that you are guilty of first-degree murder with regard to Mr. A.L. Brown.
No, sir.
You're not?
No, sir.
Well, let me ask you this, Mr. Britt. You have testified today that you and Mr. Crawford and Mr. Richardson drove in your car to Howard Road. Do you recall that?
Yes, sir.
And do you recall saying that you went there for the purpose to get money and to rob the individuals inside. Is that, did you testify to that?
Yes, sir.
Okay. And that you knew that, according to you, Mr. Richardson had a pistol with him when he went into that residence.
Yes, sir.
And you also knew, did you not, that there were people in the residence?
Yes, sir.
And you also have testified that there were 2 people killed in that house during the robbery and during the burglary. Is that correct?
Yes, sir.
So it is true, is it not, that you are guilty of felony, at least felony murder in the state of North Carolina?
No, sir.
Okay. Have you ever heard, do you know what the felony murder rule is, Mr. Britt?
Yes, sir.
Okay, the felony murder rule says, does it not, that if you are involved in a inherently dangerous felony, and as during the commission of that crime, an individual or individuals killed, that constitutes first-degree murder in the state.
Yes, sir.
Okay? And you were involved in a robbery and burglary, weren't you?
Yes, sir.
And as a result of being involved in that robbery and burglary, 2 people ended up murdered, didn't they?
Yes, sir.
So you're guilty of first-degree murder, aren't you?
That's not what I'm charged with, sir.
Well, you just said you know what felony murder is.
I do.
And that you were involved in a robbery and burglary.
Yes, sir.
And that 2 people died during that robbery and burglary.
Yes, sir.
And therefore, that constitutes felony murder, which is first-degree murder in the state.
Yes, sir.
Okay? So you are guilty of first-degree murder with regard to Mr. Brown. Is that correct?
No, sir.
Okay. So today, under oath, you're testifying that you are not guilty of first-degree murder in the case of Mr. A.O. Brown.
That's what I'm saying, yes, sir.
All right, let's talk about Mr. McKoy. You also were charged with first-degree murder with regard to Mr. McKoy, were you not?
Yes, sir.
And you're in fact guilty of first-degree murder with regard to Mr. McKoy, aren't you?
No, sir.
Okay. You've told me that you're aware of what the felony murder rule is, it not?
Yes, sir.
You have a lawyer, you had Mr. Brennan, now you have Mr. Kelly. I assume you've talked to them about the legal principles involved in this case.
Yes, sir.
And you were involved on the early morning hours of July 18th in a break-in or a burglary and a robbery, were you not?
Yes, sir.
You knew, according to your testimony, the robbery and the burglary was going to occur, did you not?
Yes, sir.
You knew that one of those individuals, according to your testimony, had a handgun with him, did you not?
Yes, sir.
And you know as a result of that, the 2 people, Mr. Brown and Mr. McKoy, died, did you not?
Yes, sir, after that.
So you were guilty of what you were charged with, first-degree murder, with regard to Mr. McKoy, are you not?
No, sir.
So, again, under oath today, it is your testimony that under that set of facts that you're not guilty of first-degree murder.
That's not what I'm charged with, sir.
I'm sorry?
That's not what I'm charged with.
Sir, you just told me earlier that you were charged by an indictment returned by a grand jury in Wake County of the first-degree murder of Mr. Brown and Mr. McKoy, were you not?
Yes, sir, at the time.
At the time. Well, those charges were dismissed by the state, were they not?
Yes, sir.
And you were happy those charges were dismissed by the state, weren't you?
Yes, sir.
And the reason you were happy was because if those charges were dismissed, then you weren't facing at least life imprisonment without parole, were you?
Yes, sir.
Okay. But it's your testimony that you said that's not what you're charged with. You mean that's not what you pled guilty to?
Yes, sir.
Okay. Well, I'm not asking about what you pled guilty to right now. I'm asking you what you originally were charged with.
Okay.
And is it your testimony? Is it your testimony that you're not guilty of first-degree murder based upon your testimony?
Based upon my testimony, I think I'm not guilty.
You're not guilty. Okay. Now, you also were charged with the burglary of Mr. Brown's home, were you not?
Yes, sir.
And are you guilty of that charge?
Yes, sir.
Oh, okay. And with regard to the robbery, you were charged with the robbery, the armed robbery, were you not?
Yes, sir.
And are you guilty of that charge?
Yes, sir.
So I understand you're guilty of those 2 charges, but you're not guilty of the first-degree murder.
Yes, sir.
Okay. Now, with regard to, you're testifying here today pursuant to a deal that you struck with the state of North Carolina. Is that correct?
Yes, sir.
And that deal included that 4 charges would be dismissed against you. 2 of those being first-degree murder, one of Mr. Brown and one of Mr. McKoy. Is that correct?
Yes, sir.
One of those is robbery. Is that correct?
Yes, sir.
And one of those is burglary. Is that correct?
Yes, sir.
Okay. And I believe you indicated that you were guilty of at least the robbery and the burglary. Is that correct?
Yes, sir.
Okay. And you know, do you not, that because those charges were dismissed, that you're no longer facing at least life imprisonment without parole. Is that correct?
Yes, sir.
And you know, do you not, that based upon what you and Mr. Lively talked about, that a judge could sentence you as little as 50 to 72 months for what you say is your involvement in this case.
Yes, sir.
And that's a big difference between life in prison without parole and 50 to 72 months in jail, isn't it?
Yes, sir.
And in fact, you've been in custody some 41 months, haven't you?
Yes, sir.
So if a judge sentenced you to 50 to 72 months, you could be out of prison in about 17 months. Is that correct?
Yes, sir.
Okay. Now, you haven't been sentenced yet, have you?
No, sir.
And Mr. Lively asked you don't know what your sentence is going to be. Is that correct?
Yes, sir.
But you've been in court before, haven't you?
Yes, sir.
You pled guilty to felonies before, haven't you?
Yes, 1, sir.
Okay. And we pled guilty to other charges, misdemeanors. Is that correct?
Yes, sir.
So you know that when you're sentenced, that judge is going to look over at Mr. Cummings and Mr. Lively and want to know what they have to say about how much help you were in this case, don't you?
Yes, sir.
And you're hoping, beyond hope, that these gentlemen stand up in front of that judge and say glowing and great things about you, aren't you?
Yes, sir.
And you're hoping that that judge, whoever that judge turns out to be, is going to give you 50 to 72 months in custody, aren't you?
Yes, sir.
Okay. So that you can be out in 17 minutes.
Yes, sir.
Okay. Now, Mr. Lively asked you about your first encounter with police with regard to this case.
Yes, yes, sir.
And he said that, I think you said it was on August the 3rd of 2014 that you were arrested. Is that correct?
Yes, sir.
And when you were arrested, they took you into a little room, didn't they?
Yes, sir.
And the law enforcement officers, they asked you a series of questions, didn't they?
They did, but I didn't answer, sir.
Well, the truth of the matter is you did answer some of them, didn't you?
I never signed anything.
Well, no, you didn't sign anything, but they told you they wanted to talk to you about the murder of Mr. Brown and Mr. McKoy, didn't they?
Yes, sir.
They told you they wanted to talk to you about the burglary that occurred on Howard Road on the 18th of July, didn't they?
Yes, sir.
They asked you they wanted to talk about the robbery. Is that correct?
Yes, sir.
And you told them you didn't know anything about that.
Yes, sir.
That's what you said, didn't you?
Yes, sir.
And in fact, you told them, I don't want to talk to you. I don't want to know anything about that. Is that correct?
Yes, sir.
Okay. And you indicated that you didn't have anything to do with that, did you?
Yes, sir.
Okay. Now, according to your testimony today, you lied. Is that correct?
I didn't lie. I didn't have a lawyer present with me.
Well, I realize that you say you didn't have a lawyer present, but you did make statements to the police. Is that correct?
I told him I didn't have anything to do with that.
Okay. And that was a lie, wasn't it?
Yeah.
Yeah, it was. So you lied. Is that correct?
Yes, sir.
And you lied to protect yourself, did you not?
Yes, sir.
And you were scared. You indicated earlier you didn't say certain things because you didn't want to be involved. Is that correct?
Yes, sir.
And on this occasion, you didn't want to be involved, did you?
Yes, sir.
And you didn't want to be criminally prosecuted, did you?
Yes, sir.
And you didn't want to go to jail for a long period of time, did you?
Yes, sir.
And you didn't walk in there and tell those officers, wait just a minute. I was just driving the car. You didn't tell them that, did you?
No, sir.
And you didn't tell them that, I didn't get anything out of this other than gas money, did you?
I never said anything, sir.
But you didn't say those things, did you?
I didn't, sir.
Okay. Now, you were interviewed again on March 27th of 2015. 2015. Is that correct?
Yes, sir.
Some 8 months after your arrest.
Yes, sir.
Correct? And before that interview, you had received what you refer to in your statement as your motion. Is that correct?
Yes, sir.
And your motion, what you're referring to is your discovery in the case. Is that correct?
Yes, sir.
And you know that the state of North Carolina has to turn over their police reports and their witness statements and physical evidence and things like that to you. Is that correct?
Yes, sir.
And you had read all that information, had you not?
Yes, sir.
And you had talked to your lawyer about that information. Is that correct?
Yes, sir.
And at some point in time, a meeting was set up between you and law enforcement on March 27th of 2015. And the purpose of that meeting was for you to come clean, as Mr. Lively referred to it.
Yes, sir.
And at that meeting, there were several law enforcement officers. Is that correct?
It was 2, sir.
2?
Yes, sir.
And then your lawyer was present?
Yes, sir.
And was Mr. Lively present?
Not in the room, sir.
Not in the room, but he was listening, wasn't he?
Yes, sir.
It was being taped and you were being recorded. Is that correct?
Yes, sir.
Okay. Prior to testifying today, have you been over that statement, that interview took just over 3 hours? Is that correct?
Yes, sir.
And during that, have you read that interview since you since you gave it before you testified?
No, sir. I haven't read it.
Okay. Well, Mr. Lively indicated to you that you looked over a portion of the statement, didn't you?
Of the video.
Mm-hmm.
Oh, yes, sir.
Okay. And that was when you were being interviewed on November the 17th of 2017, this past year. Is that correct?
Yes, sir.
Okay. So let's go back to the March 27th, 2015. Now, today you indicated, you told your version of the story, but you had several other versions of your story that you told the police on March 27th of 2015, didn't you?
Yes, sir.
And this was your time to come clean and tell the truth and reveal your involvement and other people's involvement so that you could get something for your testimony. Is that correct?
Yes, possibly.
Yes, possibly?
Yes.
Okay. But it was your intent when you were sitting in there to convince those officers that you were worthy of getting some consideration with regard to your case. Is that correct?
I don't think the law enforcement can give me any time off my sentence.
Well, I realize that, but the law enforcement officers told you this is your day to help yourself, didn't they?
Oh, yes, sir.
Yes, sir. And your lawyer told you that, sitting there in front of the law enforcement officers, that hey, don't mess this up. This is your day to shine.
Yes, sir.
Okay. And during that particular meeting with them, you told a totally, somewhat of a different version of what you told this jury today, didn't you?
Yes, sir.
Okay. Well, let's talk about some of them. You indicated that in your direct testimony that you, at the Wagstaff break-in, that during that break-in there were 2 rifles that were stolen. Is that correct?
Yes, sir.
Now, when you talked to the law enforcement on 3/27/2015, you said you never saw any rifles that came out of Wagstaff Road. Is that correct?
Yes, sir.
Matter of fact, you told them that no rifles had ever been put in my car that came from Wagstaff. Is that correct?
Yes, sir.
And you also indicated that the only time you ever saw any rifles that came from Wagstaff Road was sometime later, like a month later, that Greg had those, did you not?
Yes, sir.
But you totally denied that you saw any or anybody put them in your car the night of the burglary on July 3rd at Wagstaff Road. Is that correct?
Yes, sir.
And I believe you indicated that you didn't want to get involved, and that's why you didn't say those things, or that you didn't tell the officers right then and there that you did steal, or according to your testimony, the rifles were involved. Is that correct?
Yes, sir.
And the truth of the matter is, based upon your testimony, you were lying to protect yourself, weren't you?
Yes, sir.
Okay. So we have 2 occasions now when you, on 8/3/2014, that you lied to law enforcement to protect yourself, right?
Yes, sir.
And now we have another occasion with regard to the rifles that you lied about in order to protect yourself. Is that correct?
Yes, sir.
Okay. And you also told this jury this morning that the meeting that you had with Mr. McKoy, you remember that?
Yes, sir.
You told this jury that you and Gregory Crawford and Donovan Richardson were at that meeting. Is that correct?
Yes. Well, I told him me and Greg was there first.
Well, now I'm talking about what you told the ladies and gentlemen.
Oh, yes, sir.
Yeah, you told them that Donovan was there, didn't you?
Yes, sir.
Well, let's go back to March 27th of 2015. The law enforcement agents that day specifically asked you on 5 separate occasions who met with Gary McKoy. Is that correct?
Yes, sir.
And you told them that it was you and Greg, it was not Donovan. Is that correct?
Yes, sir.
Okay. And they asked you 2 more times, and you indicated you didn't know, you didn't remember who was at that meeting. Is that correct?
Yes, sir.
And then you indicated, oh yeah, after you got pushed by a law enforcement officer to talk about Donovan, you said, oh yeah, well Donovan was there too.
Yes, sir.
Correct? Yeah, both those things can't be true, can they?
No, sir.
He couldn't be there and not be there. Is that right?
Yes, sir.
Okay. And so on that occasion, did you lie to protect yourself?
I lied to protect Donovan.
Oh, you lied to protect Donovan. So
Yes, sir.
now we know that you'll lie to protect yourself and that you'll lie to protect Donovan?
No, sir. That's not true. No,
It's
sir.
not true. Well, I thought just earlier you told me that on 8/3/2014 that you lied to law enforcement to protect yourself. You said you didn't know anything about this.
I didn't say that.
Okay, and you lied, didn't you?
Yes, sir.
And you lied to protect yourself, didn't you?
Yes, sir.
Okay, and on March 27th of 2015, you just said you lied to protect Donovan. Isn't that what you said?
Yes, sir.
So now you were willing to lie to protect Donovan. Is that correct?
I was.
You were.
Yeah, I were.
Okay. So, again, we know now that you will at least lie on 2 occasions. One of those is to protect yourself, and the other is to protect Donovan.
Yes, sir.
Right?
Yes, sir.
Okay. Well, let's move to when after the Howard Road break-in, when you say that you and Donovan and Greg went to Greg's house, okay?
Yes, sir.
And then you indicated that you went to Andrew. Is that correct?
Yes, sir.
And that's where you say that Donovan made a statement to you that indicated that he thought he shot someone in the house, that the person had pulled a gun on him, he thought he was going to get shot, and he shot him.
Yes, sir.
Is that correct?
Yes, sir.
Okay. Now, do you remember being interviewed on March 27th of 2015, being asked about that?
Yes, sir.
You were asked on 8 different occasions, did Donovan Richardson make any statement to you about his involvement of what happened inside that house? Do you recall that?
Yes, sir.
Do you recall on 7 of those occasions that you told law enforcement that he made no statement whatsoever to you after the burglary?
Yes, sir.
Okay. And then they pushed you on it, and you said, well, the only thing he said was, can we go to Andrew? Do you remember that?
Yes, sir.
Okay. So today you testified that he made this statement to you. Is that correct?
Yes, sir.
Both those things can't be true. He cannot not make a statement and then make a statement, can he?
Yes, sir.
So you lied again on that occasion about whether he made a statement or not.
Yes, sir.
Okay. So today you said he did, but before you said he didn't.
Yes, sir.
Okay. All right. Let's talk about the bullets that were found in your gun. Okay. You remember?
Objection to his gun.
Staying.
I apologize. That was motion straight from my standpoint. That was a slip on my part. Let's talk about the bullets that you indicated that were found in your car at the day that you were arrested, that you remember being August the 3rd, 2017. Okay?
Yes, sir.
2014, I apologize. So, Mr. Lively said that you never talked to law enforcement about those bullets until November the 17th of 2017, didn't he? That's what he asked you.
Can you re-ask your question?
Well, Mr. Lively asked you that the only time you discussed those bullets with law enforcement was on November the 17th, 2017, about 2 months ago, 3 months ago. Isn't that correct?
Oh, yes, sir.
And you said yes. That's the only time I discussed those bullets with law enforcement. Isn't that correct?
I mean, they had interviewed me and said there were shells left in my car.
Precisely. On March 27th of 2015, some 2 years earlier,
Yeah.
law enforcement asked you questions and talked to you about those bullets in that car. Is that correct?
Yeah, they asked about it, yeah.
And you told them that you didn't know they were there, right?
Yes, sir.
You also told them that if you had known they were there, you would have taken them out of your car, didn't you?
Yes, sir.
Okay? So you were willing to obstruct justice in order to protect yourself, willing to destroy evidence. Isn't that correct?
Well, I wouldn't know if they were evidence or not.
Okay. Well, you were concerned about them that day with law enforcement on March 27th of 2015. You were concerned. You knew the bullets were found there, right?
Yes, yes.
And you were concerned enough about them to tell them, had I known they were there, I'd have moved them.
Yes, sir.
Taken them away, right?
Yes, sir.
So you were willing to obstruct justice to protect yourself, weren't you?
I didn't know they had anything to do with the crime, sir.
Well, then, if you didn't know they had anything to do with the crime, then you wouldn't have been particularly worried about removing them if you had known they were there, would you?
If I'd known they were there, then I would have moved them.
Right. And the reason you would have moved them is because you thought they were important with regard to the crime, right?
No, sir.
Oh. So you moved them for some other reason, is that because you like to keep your car clean?
Well, objection, he didn't move them.
You would have moved them because you want to keep your car clean.
I would have moved them because there shouldn't be shell casings in my car.
The reason you moved them, isn't it, Mr. Britt, is because you were afraid that they were going to be used as evidence against you in your first-degree murder charges.
Objection, again, he didn't move them.
I apologize. Strike that out. The reason that you said that you would have moved them is because you were afraid they would be used as evidence against you in your charges of first-degree murder, burglary, robbery, and conspiracy to commit those crimes, right?
No, sir. I just would have moved them because they shouldn't have been in my car.
Okay. All right. Now, you indicated that Donovan borrowed your car the morning before you were arrested. Is that correct?
Yes, sir.
And that you knew that those bullets, according to your testimony, you knew those bullets were not in that car. Is that correct?
Yes, sir.
Okay. And the bullets were found in the passenger seat, passenger pocket on the passenger door. Is that correct?
Yes, sir.
And that's where you said Donovan was sitting. Is that correct?
Yes, sir.
On the night of the robbery and burglary and murders?
Yes, sir.
Okay. But you told law enforcement on 11/17/2017, 2-3 months ago, that you think Donovan set you up by putting those bullets in your car. Is that correct?
Yes, sir.
Okay. Now, it wouldn't be very smart, would it, to put those bullets in the same pocket on the same door where Donovan was sitting, would it be? Would it?
No, sir.
Okay. All right. Let's talk about Wagstaff Road again, or the house on Wagstaff Road. You indicated to this jury that during that robbery, that Greg Crawford came out of the house once, went back in the house, and then both Donovan and Greg Crawford came out of the house, and then you drove them away. Is that correct?
Yes, sir.
Okay. Now, you remember talking to the police on March 27th of 2015, and you telling them that they went into the house and they both came out and then they went back in again. Do you recall saying that?
No, sir.
Okay. May I approach you?
Yes, you may.
May I approach you?
Yes.
May I approach you, Richardson?
Yes, you may.
Mr. Richardson, I'm going to hand you what's been marked as exhibit number 1 and indicate to you that's a transcript of the statement that you gave on March 27th, 2015. And I'd like to direct your attention to page 22 of that statement.
You turn to page 22?
Yes, sir. You see the page numbers at the top?
Yes, sir. Yes, sir.
On page 22 at the top, you indicate that it was Greg's idea to break into the Wagstaff house. Is that correct?
Yes, sir.
Okay. Now, if I can direct your attention to the bottom of page 22 and the top of page 23. Do you remember telling the officer that they went out of, both of them went in and out of the house twice?
Yes, sir.
Okay, so that's what you told the officers on March 27th of 2015, is that correct?
Yes, sir.
But today you say that only Gregory Crawford came in and out, is that correct?
Yes, sir. It was dark that night, sir. And I only had my back door open, so possibly both of them could have came out at the same time. But I know for sure that Greg came out.
So, is your testimony you don't know who came out, when they came out? Is that your testimony because it was dark?
No, I do know who came out. I know they both came out on the second time.
Now, during according to your testimony, the robbery and burglary at the Howard Road house, you indicated that Donovan and Greg Crawford went into the house. Is that correct?
Yes, sir.
And you indicated you stayed in your car and that at some point in time you called Greg Crawford's number. Is that correct?
Yes, sir.
And you recall telling the police that after you called Greg's number and no one answered, that you fell asleep?
Are you talking about Howard Road or Wagstaff Road?
Howard Road.
Oh, yes, sir.
Okay. So, during the robbery, you say you were in your car and during some point at that time, you were asleep. Is that correct?
Yes, sir.
Now, during the interview on March 27th of 2015, do you recall telling the law enforcement officer, do you remember telling the law enforcement officer that you were trying to save yourself?
No, sir.
You don't? Let me refer you to page 64 of that document. Do you remember saying to the officer that you were trying to save me?
No, yes, sir.
That's what you told the officers that day, didn't you?
Yes, sir.
Now, you recall today that you told, ladies and gentlemen of this jury, that Greg was the individual who set up the robbery and burglary at Wagstaff Road, do you not?
Yes, sir.
And do you recall being interviewed on November the 17th of 2017 of this year?
Yes, sir.
And you were interviewed also on December 29th of 2017 by law enforcement, is that correct?
Yes, sir.
And during those meetings, Mr. Cummings and Mr. Lively were there, were they not?
Yes, sir.
Okay. And do you recall telling law enforcement that day that Mr. Richardson was the one who set up the Wagstaff Road burglary?
I don't remember, sir.
Okay. So your testimony is that you didn't say that?
My testimony is that I don't remember.
Okay. Well, if Investigator Gray's report indicates that you said that, do you have any questions about the fact that you said that?
I might say that both of them had a part to play in that situation.
So on March 27th of 2015, you said Greg set it up, is that correct?
Yeah.
This morning you said Greg set it up, is that correct?
Yes.
And on 12/29 or 11/17, you indicated that Donovan set it up, is that correct?
Yes.
And now you're saying it was both of them that set it up.
I'm saying that they were all both in the same situation. So the way that it was said and it was put to me, it was said that they both set it up.
So your testimony is now that they both set it up, is that correct?
Well, the way the question was asked to me at the time, they said, who set it up? And as far as like the whole situation, you know, we all set it up. We all was a part of that.
Well, do you recall telling this jury this morning, according to your testimony, that Mr. Richardson sold the dog?
Yes, sir.
And you recall when you were interviewed on March 27th of 2015 that you told the law enforcement officers and the DA on that occasion, Mr. Crawford sold the dog?
Yes, sir.
Okay. Well, both of those things can be true, can it? Mr. Richardson sold it or Mr. Crawford sold it, is that correct?
Yeah.
Okay. Now, you also indicated on 12/29/2017 to Mr. Cummings and Mr. Lively that just after according to your testimony, just after the burglary at Howard Road on July 18th of 2014, that you washed all your clothes, didn't you?
Yeah, I did wash my clothes. Yes, sir.
Now, Mr. Britt, Mr. Lively asked you some questions about your previous criminal record, is that correct?
Yes, sir.
And I think he asked you if you had been convicted of 5 misdemeanors of larceny, is that correct?
Yes, sir.
And that was back in 2011, is that correct?
Oh, yes, sir.
Okay. And so back in 2011, you were stealing from people, is that correct?
Oh, yes, sir.
Okay. And you also were convicted of 5 counts of breaking into people's motor vehicles, is that correct?
Yes, sir.
Okay. And so back that far, you were breaking into people's cars, is that correct?
Yes, sir.
And you had to come to court, is that correct?
Yes, sir.
And you had to plead guilty, is that correct?
Yes, sir.
And you got probation, did you not?
Yes, sir.
Okay. And then you were convicted of 2 counts of drug paraphernalia, is that correct?
Yes, sir.
And in 2012, you were pled guilty to larceny from person that you stole from an individual who was immediately in front of you. You pled guilty to that and that you were convicted of that charge, is that correct?
Yes, sir.
And you originally were charged with common law robbery.
Objection.
Hold on. Members of the jury, step outside, please. Record reflect jury's left the courtroom. I hear from you, Mr. Lively.
Your Honor, again, with regard to impeaching the defendant with his prior criminal history, I think that the defense is limited in what they can ask to what he pled guilty to, what the sentence was when he pled guilty to it, and in what court. Anything beyond that, I think is outside of the scope for impeachment purposes. I don't know if Mr. Gaiman has another purpose that he wants to propose.
Mr. Gaiman?
My purpose, Your Honor, is to show that the system before he got a plea bargain in that particular case, and that he understands the nature of plea bargain, and this isn't his first rodeo as far as all that.
Well, you can certainly ask him whether he pled guilty pursuant to a plea bargain, but not what he was originally charged with. Because people receive plea bargains all the time for. You can impeach with prior crimes. And evidence of prior crimes are not admissible or otherwise admissible. There is a way that you can show he has been through the system, know how plea bargains work, that you can elicit from him without going into what he was charged with. So let's go ahead and bring the jury back in.
Yes, sir.
Proceed proceed, Mr. Gaiman.
Thank you, Your Honor. Mr. Britt, in 2012, you were convicted of larceny from person. Is that correct?
Yes, sir.
And you were represented by an attorney in that case, were you not?
Yes, sir.
And you and your attorney and the DA agreed to that deal in that case too, did you not?
Yes, sir.
Mr. Britt, Mr. Lively asked you some questions about the contacts that are contained in your phone. Is that correct?
Yes, sir.
And one of your contacts is Jamila Gillen. Is that correct?
Yes, sir.
And the telephone number for that contact is 919-635-6109. Is that correct?
Thank you.
I apologize. Strike that. 910-635-6105.
Yes, sir.
Is that correct?
Yes, sir.
Okay. Who is Catherine Irby?
I don't know, sir.
Okay. And what about Oscar Rio Galdino?
I don't know who that is, sir.
Okay. Now, Mr. Britt, on March 27th, 2015, when you were interviewed by law enforcement, did they ask you the question of whether Gregory Crawford made any statements to you after you left the Howard Road residence?
Yes, sir.
And did you tell them that Gregory Crawford, in fact, did make a statement to you after you and Mr. Crawford and Mr. Donovan, Mr. Richardson, according to your testimony, left the Howard Road residence?
Yes, sir.
Okay. And did you hear what Mr. Crawford said loud and clear?
Oh, yes, sir.
And on 3/27/2015, when you talked to law enforcement, did you tell them and the DA what Mr. Crawford had said?
Yes, sir.
Now, again, on November the 17th of 2017, when you were interviewed again by Mr. Cummings and Mr. Lively and law enforcement agents, you remember that?
Yes, sir.
And in that meeting, you were asked, were you not, what Mr. Crawford said to you after you left the house on Howard Road?
Yes, sir.
And then again, and did you tell them?
Oh, yes, sir.
Okay. And then again on December 29th of 2017, some 10, 11 days ago, again you were interviewed by Mr. Cummings and Mr. Lively, is that correct?
Yes, sir.
And I believe Mr. Gray was there, Investigator Gray was there too?
Yes, sir.
And you were asked again what Mr. Crawford said to you after you left the Howard Road house, is that correct?
Yes, sir.
And again, you told them what Mr. Crawford said, is that correct?
Yes, sir.
What did Mr. Crawford tell you?
Objection. Hearsay.
Like you heard.
All right, members of the jury, if you go to the jury room. Let the record reflect, jury's left the courtroom. What did Mr. Crawford tell you, Mr. Britt?
He said that he had he thought also he had shot somebody in the house, and that was pretty much it.
And when did he tell you this?
He told me a little bit after we were riding away from Howard Road.
I'll hear from defendant or state's counsel.
Your Honor, first of all, I don't believe Mr. Crawford's going to testify at this trial, so it would be hearsay for that purpose. And if he were allowed to answer that question, then I think it would open the door to Mr. Crawford's full confession, which he gave to law enforcement when he was arrested on August 1st. So, we would object for that reason.
I'll hear from the defense.
Your Honor, number one, that we would submit that it is an excited utterance, number one. Number two, that Mr. Crawford will not testify. We have a letter from his attorney indicating that if called, he will take the fifth and that he will not testify. We submit that he is unavailable and it is a statement against interest. In addition to that, we submit that it doesn't open the door for a separate statement statement given to law enforcement by Mr. Crawford, if they want to cross him as to what Mr. Crawford, in addition to that, may have told this witness, then they can cross-examine him, but not as to a completely different statement given to law enforcement.
Well, under Rule 806, when a hearsay statement has been admitted in evidence, the credibility of the declarant, in that case that would be Mr. Crawford, may be attacked, and if attacked, may be supported by evidence which would be admissible for the purposes if the declarant had testified as a witness. So any inconsistent statements or statements that could be construed as inconsistent would be admissible under Rule 806.
Well, I would submit that the statement that Mr. Crawford gave to law enforcement is not, I don't see any way it can be argued that it was inconsistent with what he just testified that Mr. Crawford said.
What did he say to the, what did Mr. Crawford say in his confession?
Your Honor, what Mr. Crawford said in his confession is that he and Donovan Richardson entered the residence at Howard Road, that they went into the room where Mr. Brown was, that Mr. Crawford was by Mr. Brown's bed, that Mr. Brown then raised up, that Donovan shot him 2 or 3 times, and then at that point Mr. Crawford took the .38 revolver from Mr. Brown's hands, went to the other room where David McKoy was discovered sleeping, and then maybe made some statement. He told him not to move, and he felt that Mr. McKoy was moving, and then shot him at that time.
Mr. Britt, can you recall as best you can what Mr. Crawford told you?
He said that he had shot somebody, and that he had the revolver at the house.
I'm sorry, I didn't hear that last part.
He had the revolver out the house. He had the gun out the house.
And Your Honor, I think that what Mr. Britt might also testify to is that Mr. Richardson told him that Mr. Brown had a rifle and pointed it at him, and so that would be inconsistent with what Greg Crawford would have told him about that.
Well, on the issue before the court, why is it not an excited utterance or present sense impression?
Well, Your Honor, I think that Mr. Britt also testified that nothing was said in the car immediately after the homicides at Howard Road, and nothing was said back at Greg Crawford's house, which is where they went next and spent some period of time, and then it was only when we were back in Anger that statements were made to him.
Well, but then wouldn't the statements that Mr. Crawford made tend to impeach him in his testimony that no statements were made?
No, Your Honor. I think what Mr. Britt's saying is that the statements were made, but at some later time, be outside of the scope of where it might be considered an excited utterance or a present sense impression.
When did Mr. Crawford explain to you that he may have shot someone?
Like on the way he's back to Andrew.
After you'd already been at his house?
Yes, sir.
And how long a period of time was that?
From Howard Road to Andrew.
Well, how long after they had gotten in the car on Howard Road how long after that did that occur?
Probably about like 35 minutes.
What was his demeanor when he said that?
He didn't seem nervous. Mainly calm.
After Mr. Crawford returned to the car, court don't know how long the shooting occurred prior to that. At the time he made the statement, he was calm, was not excited. It doesn't qualify as an excited utterance under 803-2, so the court's going to sustain the objection. Yes.
Your Honor, we're also offering as a statement against penal interest, and we're going to hand up as a board here exhibit.
Under what rule?
Under rule.
All right, how is this not a statement against penal interest?
That's what I handed you for the record is defendant's voir dire exhibit number 1, which is a letter from Mr. Crawford's attorney.
Right, B1 is defendant's voir dire exhibit 1 is admissible, or is it? The court will accept that.
We think that if you were to find that this particular statement by Mr. Crawford was against penal interest and he was unavailable, that we would contend that any statement to include his full confession would also be against his penal interest and would therefore be admissible, and that allowing this would be opening the door to every statement Mr. Crawford made.
And the problem with that, Your Honor, is that they want to backdoor Mr. Crawford's confession, and Mr. Crawford's statements about what Mr. Crawford did are admissible as a statement against penal interest.
How, to the extent that the statement that Mr. Crawford made to Mr. Britt could be construed as that he was the shooter and not Mr. Britt, when Mr. Crawford's statements that he made later on tend to impeach that?
That Mr. Crawford's statements that he was the shooter and not...
Right, based off what Mr. Britt has testified to, can it be, is the inference that Mr. Crawford was the one who did the shooting and not Mr.
Correct.
Richardson?
No. As to, right now we have a situation where Mr. Britt has testified that Donovan Richardson told him that he shot a man in the house after the man raised up and pointed a gun.
Right.
The state in opening statement never said anything about who shot Mr. McKoy, the man who's found in his bed. The clear implication here, the clear implication of Mr. Britt, is that that's who Mr. Crawford is talking about, the second man. Because they're talking about two different, under Mr. Britt's testimony, Mr. Britt would testify that on the ride to Andrew, Mr. Crawford says to him, I shot him. That after they're at Andrew, that the next morning, apparently, per his testimony earlier, that Mr. Richardson says, hey, come outside, let's talk. And Mr. Richardson says, I think I shot somebody. The man raised up and had a gun, and I shot him. And throughout Mr. Britt's March 27th interview with law enforcement, he's talking about the fact that there were two decedents. And that's when that's what I perceived is Mr. Crawford admitted to shooting one and Mr. Richardson. And again, Your Honor, the reason to this point in the trial, the state in opening statement apparently made the decision to not say that the evidence is going to show that Gregory Crawford shot David McKoy. And we certainly don't want, if the jury chooses to believe some portion of Mr. Britt's testimony, we don't want the jury believing that Donovan Richardson is the one who shot David McKoy in his bed, in the face, as the state said over and over during the course of their opening statements.
Yeah.
And we want to dispel the jury of that thought. And we're in the position of the state hasn't offered those statements. The state hasn't said anything in an opening statement about who shot Mr. McKoy. And now we're in a position where we have a hearsay statement of Mr. Crawford against his own interest, where all of the evidence, the corroborating circumstances, as Rule 804B3 states, show that it's Mr. McKoy. And that certainly doesn't open the door to then Mr. Crawford giving some separate statement to law enforcement where the state wants to offer it not about what Mr. Crawford says Mr. Crawford did, but about what Mr. Crawford says Mr. Richardson did. That's their purpose in wanting to put in Mr. Crawford's later confession to law enforcement. Because the statement to Mr. Britt that Mr. Crawford made, that Mr. Britt's testifying to, Mr. Crawford doesn't say anything about what Donovan did or didn't do, according to Mr. Crawford. He simply says, I shot somebody. I think I might have heard him. I think it was.
Judge, we objected to this question because we don't want any statement from someone who's not testifying at this trial to be admitted into evidence. You know, we're merely saying that if a statement from Mr. Crawford is allowed to come in, then we need to take up that issue. But we're objecting to this at this point because Mr. Crawford's not going to testify at this trial. Now, I think that Mr. Britt has also said that what Mr. Richardson said to him was that the person raised up and pointed a gun at him, and that's when he shot him. Now, the state made the decision, or we made the decision, not to talk about who shot who in the house because Mr. Britt hadn't testified yet. There's a motion to prevent us from making that argument to the jury at the close of the evidence. The court has reserved ruling on that.
No, our argument is to prevent them from arguing that Mr. Richardson's the one who shot Mr. McKoy.
And at this point we're not arguing that, and it is available for them to argue that Mr. Richardson did not shoot Mr. McKoy because based on what Mr. Richardson told Mr. Britt, and we haven't heard the physical evidence from CCBI yet, but what that's going to indicate is that Mr. Brown was shot twice, and it's the state's theory that Mr. Richardson shot Mr. Brown and not Mr. Coy, but we just haven't gotten there yet.
All right, so tell me how Mr. Crawford's statement is not, he's unavailable based upon letter from his attorney that he will invoke his rights under the Fifth Amendment should be called, so he's unavailable. So tell me how it's not a statement against penal interest that he made. I mean, that's going to be a separate issue from what you're allowed to cross-examine him on or redirect him on. I mean, you can certainly ask him. Mr. Crawford didn't say he shot two people, just one person. Mm-hmm. I mean, and that's a separate issue of whether some statement of Mr. Crawford may be admissible later on, either as opening the door or impeachment. What I need to know is tell me how Mr. Crawford's statement was not a statement against penal interest under 804B3. Now, I know you weren't going to offer any hearsay evidence in, but they are, and it appears from reading the rule that it is not inadmissible simply because it is made by someone, a declarant who's not in court testifying.
I have just amendment, Your Honor. Against penal interest.
That it's not against.
That it's not against penal interest. We're not arguing that, but I think we also have to determine what it does open the door to as we go forward.
And again, as we go forward, we may address that issue, but that issue is not before me right now.
Yes, sir.
The only issue is whether the statement's admissible. The objection is overruled.
Thank you, Your Honor. Mr. Zinstar's going to have a moment
Yes.
before we bring through that.
Yes, Your Honor, during Mr. Britt's direct testimony, he made the statement when Mr. Lively was asking him questions about what happened in the time period when they were leaving Howard Road. They went and stashed, and they were going to Crawford's apartment to stash the guns. Mr. Britt made the statement that Greg told me that he had a place to sell the Tommy gun. And he testified to that statement from Mr. Crawford. And we are going to seek, because that's a statement from Mr. Crawford that has been introduced by the state into evidence, we are going to seek to impeach Mr. Crawford as a hearsay declarant under the rule the court just cited.
All right.
And we're going to seek to impeach him as we're allowed under Rule 609. We're allowed to impeach by asking about the conviction length of sentence, but the rule also specifically allows you to use the record to do that. And we have certified copies of the judgments in Mr. Crawford's case to do that with. And I We raise that now because we don't want to have to shuffle the jury right back out again.
I'll hear from the state.
Is that, he's talking about asking this witness about Mr. Crawford's plea?
Correct.
I mean,
We intend to ask him that he made a statement on, he testified on direct testimony about a statement made by Mr. Crawford to him in the time period shortly after the crime about disposing of the firearm stolen from the gun. We're going to seek to impeach that under Rule 806. It's a hearsay statement that we can impeach under Rule 806. And Rule 609, Your Honor, which deals, Rule 609 specifically allows the impeachment of a declarant with their prior criminal conviction. The rules and the case law specifically say that you can impeach with the fact of the crime charge, the date of conviction, and the sentence imposed. And the rule specifically says in 609A that evidence the witness has been convicted of a felony or certain misdemeanors shall be admitted if elicited from the witness or established by a public record during cross-examination or thereafter. We have the public record of Mr. Crawford's convictions and sentence in the form of certified copies of his judgments, which we would, which will mark the defense exhibits 2 and 3.
and so you're going to introduce those into evidence?
We're going to ask him if he's aware of these convictions, Your Honor, and we're going to show him the judgments. We're not going to offer them at this time.
Well, has he seen, unless he's seen them before, I'm not going to allow him to read those judgments if he hasn't seen them before.
Your Honor, he's well aware that Mr. Crawford's pled guilty and has been sentenced to life.
What says the state?
Maybe I'm confused. Is he saying that, is defense saying that they want to impeach Crawford's statement that he sold a Tommy gun or that he would dispose of the Tommy gun by introducing his conviction?
I think they're going to impeach his credibility is what they're doing under 806 and...
Okay, for purposes of what he's testified, what he's about to, what Mr. Britt is about to say, and then the Tommy gun.
Yes.
And then impeach his credibility.
Yes.
As to the truthfulness of those statements.
By
Okay.
eliciting evidence under Rule 609.
As to the truthfulness of the statements related to the Tommy gun, yes.
Okay, well, I think it would apply to all the statements, but I'll let them, we'll worry about that later on.
Well, I mean, it's... You're not 609 talks about not impeaching statements. It talks about impeaching the credibility of the witness generally. So, I mean, once it's entered, either party could argue, should a jury so find the conviction of whatever those offenses could be used to impeach Mr. Crawford's credibility.
And obviously, Your Honor, we would be arguing the fact that he pled guilty to the exact statement that he made to Mr. Crawford with respect to that statement is something that the jury can consider.
Say that again?
Your Honor, with respect to Mr. Cummings' argument, I think that it's for the jury to determine what's impeaching or not impeaching. I don't think that affects the admissibility under 609 of what we're trying to do.
All right, so if the conviction comes in and it comes in under 609, it comes in for purposes of?
Impeachment.
Okay.
Of the hearsay declarant statement.
In what other purpose?
That's what it comes in.
All right, and it can only be used for the purpose of impeaching Mr. Crawford's credibility with respect to the hearsay statements. Understand?
Yes.
All right. Any objection?
Well, I don't know that my objection would be fruitful. I don't have anything to say in light of what reading of the rules seems to be.
Okay. All right. Let's go ahead and bring the jury back in.
Yes, Your Honor.
You may proceed, Mr. Gammon.
Thank you, Your Honor. Mr. Britt, when we took a break, I had asked you what statement Mr. Crawford had made to you after you had left the house on Howard Road. Is that correct?
Yes, sir.
Can you tell us what Mr. Crawford said to you?
He had said that he asked me if I heard any gunshots outside the house, and he asked me that he asked me if I heard any dogs barking, and then that's when he told me that he had shot somebody in the house.
On direct testimony earlier today, you testified that Mr. Crawford told you that he had a binder for the Tommy gun. Is that correct?
Yes, sir.
Now, you are aware, are you not, that Mr. Crawford has pled guilty to the 2 counts of first-degree murder involved in this case and has received life imprisonment without parole?
Yes, sir.
Members of the jury, with respect to the evidence concerning Mr. Crawford's criminal conviction, you may consider that evidence for one purpose only. If considering the nature of the crime, you believe that this bears on his truthfulness and the statements he may have made to people, then you may consider it together with all other facts and circumstances bearing upon his truthfulness in deciding whether you will believe or disbelieve the statements that Mr. Crawford made. You may not consider his criminal conviction for any other purpose.
Mr. Britt, in addition to the point of your testimony, what Donovan told you after you left Howard Road, either that late that night or the next morning, do you remember that?
Yes, sir.
Mr. Richardson also told you that Greg shot someone in the house. Is that correct?
Yes, sir.
And then there are other things that were in your discovery that you said you lied about. In March of 2015, you initially say that you were not present for the meeting with Gary McKoy, correct?
I said I was.
Eventually you did. At
Yes, sir.
first you did not.
Yes, sir.
And even after you said you did, for a time you refused to say that Donovan had been present. Is that correct?
Yes, sir.
Okay. But Gary McKoy's statement was in your motion of discovery, wasn't it?
Yes, sir.
Okay. So when confronted with that, you admitted that you had lied and you came clean on that.
Yes, sir.
All right. Objection.
This strike as to came clean.
And you've also testified about phone calls that you made to Greg Crawford's phone while the robbery and murders inside Howard Road were occurring. Is that correct?
Yes, sir.
And you were shown some call detail records about that. Is that right?
Yes, sir.
Okay. Your Honor, may I approach the State's Exhibit 99?
Yes.
Mr. Britt, this morning you testified about the contact information in your phone. Is that right?
Yes, sir.
Okay. And we looked at number 274. Is that correct?
Yes, sir.
And there's a phone number there, 919-842-1059. Whose phone number was that?
That was Donovan's phone number.
That was Donovan's phone number. Okay. And then these are the call detail records in State's Exhibit 99. And I showed you a portion of them this morning where now, is this your phone number, 919-586-4842?
Yes, sir.
And so I believe I pointed out 2 phone calls you made that evening at about 11:45 p.m. and 12:16 a.m. that morning to Greg Crawford. Is that correct?
Yes, sir.
Okay. And you recognized your phone number and his phone number and the calls, correct?
Yes, sir.
And that he didn't pick up.
Yes, sir.
All right. At the line just above the 11:45 phone call, there's another phone call made at 11:45 and 15 seconds. What number is that to?
Oh, that's Donovan's number.
Okay. So did you get any answer on Donovan's number?
Yes.
Okay. And just before that, another call was made to Donovan's number at 11:37:34. Is that correct?
Yes, sir.
Okay. And then immediately after calling Mr. Crawford's number at 12:16 a.m., Who do you call at that time?
Donovan again.
Okay, and that call was made at 12:17 a.m. Is that correct?
Yes, sir.
Okay, so you were attempting to reach both of them inside the house?
Yes, sir.
And you weren't able to reach Mr. Crawford and Mr. Richardson?
Yes, sir.
The defense asked you about pleading guilty to a larceny from the person, and you did.
Yes, sir.
Thank you, sir. Nothing further.
Recross.
Thank you, Your Honor. Mr. Britt, while we're on that subject, you indicated you pled guilty to larceny from person. Is that correct?
Yes, sir.
Now, when you were arrested for that particular charge, you were interviewed by the police, were you not?
Yes, sir.
And you lied to them, didn't you?
Objection.
Members of the jury, please step into the jury room.
So I ask you not allow for him to go into that, into the facts of that case.
Judge, again, it's separate and apart from the conviction. I'm asking him, was he interviewed by the police on a prior occasion where he lied?
What's the relevance of whether he lied on that prior occasion?
I'm sorry, I didn't hear you.
What is the relevance of whether he lied on that prior occasion?
Credibility with regard to what he had to say to the police on that occasion.
On the occasion of the common law?
Yes, sir.
And so how's that relevant here?
Well, again, it's a situation where he was interviewed by the police and that he lied to the police.
So you're using it to attack his credibility?
I am using it to show his credibility and
to show his propensity for lying?
And propensity for lying, yeah.
Isn't that prohibited?
Well, it's
what's the, I guess, what, typically we can impeach his credibility through prior inconsistent statements, by opinion, by reputation evidence. And you want to attack it here by going into specific instances, is that correct?
well, it is a situation where he pled guilty from larceny from the person. He gave a prior statement that he was at home all day and that he basically lied to the police and then turned around under oath and pled guilty and admitted his guilt.
608B, I can't allow specific instances of conduct if probative on truthfulness or untruthfulness, and that they may be inquired into on cross-examination, but they can't be proved by extrinsic evidence. What do you say about that?
Well, then I would say that would mean that he shouldn't be able to ask that question, and that the objection should be sustained.
I think what the rule prohibits is that if they're stuck with whatever answer he gives, they can't try and prove otherwise. That's the extrinsic.
Yes, sir.
But you may, let's bring the jury back in. Objections overruled.
I specifically allow it in this particular case in my discretion because
the situations are sufficiently similar to go to the probative value of truthfulness or untruthfulness.
Your Honor, if you do allow that, is this going to open the door to talking about the facts of that case from his perspective?
No.
I'm not going to ask. I just want to know if he lied to you.
You can ask him why I did. If you want to. You may continue.
Thank you. Your Honor, Mr. Britt, Mr. Britt, when we took that short break, I was asking a question about your conviction for larceny from person. Do you remember that?
Yes, sir.
And upon your arrest for that particular case, you were interviewed by the police, were you not?
Yes, sir.
And you lied to the police about your involvement, did you not?
Yes, sir.
Sir?
Yes, sir.
Now, Mr. Lively asked you a few questions a few minutes ago about you being confused about something I asked you, so I want to be real clear, and if you don't understand what I say, please ask me to repeat it. When I was asking you earlier about whether you were guilty of first-degree murder, I believe you told Mr. Lively that you were confused about what I was asking about. Is that correct?
Yes, sir.
Okay. Well, I'm not asking about what you pled guilty to. We have that with regard to the plea agreement. What I'm asking you is that you were charged or indicted for the first-degree murder of Mr. Brown. Do you agree with that?
Yes, sir.
And based upon your testimony and what you say you did, you're in fact guilty of first-degree murder of Mr. Brown. Isn't that correct?
Objection. It's asking for a legal conclusion.
Overruled.
You may answer my question.
Yes, sir.
Okay. You are, in fact, is that correct?
Yes, sir.
And you were also charged with the first-degree murder of Mr. McKoy. Is that correct?
Yes, sir.
And based upon your testimony, you're in fact guilty of first-degree murder with regard to Mr. McKoy, are you not?
Yes, sir.
And you're aware, are you not, that if you are guilty of those offenses of first-degree murder, that subjects you to at least life imprisonment without parole under North Carolina law. Is that correct?
Yes, sir.
Now, may I approach briefly, Your Honor?
Yes, you may.
Do you remember Mr. Let me get an exhibit. I'm sorry.
Yes.
Can you tell us what the maximum term of imprisonment is indicated on the plea agreement for the three charges that you pled guilty to?
407 months.
Okay, and you're aware, or you're not, that you're not facing 407 months. Is that correct?
Yes, sir.
That 407 months is reserved for people who have the worst criminal records under the law. Is that correct?
Yes, sir.
Okay. Now, Mr. Lively asked you on redirect about your statement on 3/27/2015, and he asked you if you told the police on a couple of different occasions that Mr. Richardson made a statement to you about him shooting someone in the house. Is that correct?
Yes, sir.
Now, it is true, is it not, that 5 times within the statement that you made on March 27th, 2015, you indicated that Mr. Richardson made no statement to you after you left the Howard Road residence. Is that correct?
Yes, sir.
Okay. Now, Mr. Lively also asked you on redirect about your knowledge of reports or whatever about the Wagstaff Road break-in. Do you recall that?
Yes, sir.
Okay. Now, before you came into court today, you were aware and had read the reports with regard to that particular break-in, had you not?
No, sir. It wasn't in my motion.
Okay. Is it your testimony that you've never read a police report or discussed that with Mr. Cummings or Mr. Lively?
Yes, we discussed it, but I haven't read anything.
Okay, but you discussed it before coming into court and testifying today?
Yes, sir.
Okay. Now, when you testified this morning that Donovan made the statement to you that the man pointed a gun at him and he thought he was going to shoot him and that he shot the man, do you recall that?
Yes, sir.
You described Donovan as being distraught and sad when he was telling you about that, isn't that correct?
Yes, he was sad. Yes.
And you told the police on 3/27/2015 2015 that he was sad and distraught, didn't you?
Yes, sir.
Now, you never saw Donovan with a revolver that evening, did you?
No, sir.
Or the next day, did you?
No, sir.
Okay. The only person you saw with a revolver was Greg Crawford, is that correct?
Yes, sir.
And you saw Greg Crawford take the revolver, based upon your testimony, and put it stash it underneath his bed at his house, is that correct?
Yes, sir.
This is the toll record that Mr. Lively asked you about earlier this morning. It indicates, and I believe your testimony was, that you made a telephone call to Greg Crawford at 12:16 in 57 seconds on the 18th. Is that correct?
Yes, sir.
Is that the call? Is it your testimony that is the call that you made to Greg Crawford when you say that he was in the house?
Yes, sir.
Now, Mr. Richardson, it is true, is it not, that prior to the burglary and robbery of the house on Howard Road, it is true that there was absolutely no plan to hurt anyone during that robbery and burglary, isn't that correct?
Yes, sir.
And in fact, there was no intentions on anyone's part to hurt anyone, is that correct?
What anyone's intentions were?
He can state his intentions and the intentions of the others if he knows what they were.
No, sir. We didn't have any intentions.
Okay. And that's what you told the police on March 27th, 2015, is that
Yes,
correct?
sir.
Okay, thank you. That's all the questions I have now.
Redirect.
But it was your testimony in 2000, or it was your statement in 2015, and it's your statement in 2017, and your statement in 2018 that Donovan Richardson went into the house at Howard Road with a gun that night. Is that correct?
Yes, sir.
Okay. To commit a robbery and a burglary, correct?
Yes, sir.
And that you were aware that there was at least one person in the house.
Yes, sir.
And that Donovan Richardson and Greg Crawford went into the house, correct?
Yes, sir.
And that you yourself never went into the house.
Yes, sir.
Thank you. Nothing further.